first case to come before us today is State versus Moreland. And the state, the appellee has waived, so we're just going to hear from the appellant today. And you have your 15 minutes. Thank you.
Good morning, Your Honors, and may it please the Court. I'm Jacqueline Corgan, and I represent Mr. Frederick Moreland, the appellant in this matter. Mr. Moreland challenges his conviction for aggravated robbery with a gun specification for 4 reasons, and also asks this Court to remand his case for resentencing. The 4 grounds that Mr. Moreland argues merit reversal in this case are, first, that he was denied the ability to introduce potentially exculpatory evidence during his trial. Second, that prosecutorial misconduct denied him due process. Third, that his conviction is against the manifest weight of the evidence. And fourth, that he was denied the effective assistance of counsel during his trial. As for Mr. Moreland's first ground for challenging his conviction, that denying him the ability to introduce potentially exculpatory evidence denied him due process during the course of his trial. Now, there were 2 separate categories of potentially exculpatory evidence at issue. First, there was alibi evidence, and second, there was information from a co-defendant's Facebook page that Mr. Moreland wished to introduce. As for the alibi evidence, of course, alibi evidence is generally governed by Criminal Rule 12.1, which requires a written notice of alibi giving specific information about where the defendant was while the crime was being committed, and it has to be given not less than 7 days prior to trial. But there is an exception. The trial court can admit the evidence nonetheless, even if such a notice is untimely, if justice so requires. And the courts in Ohio have generally said that that rule has to be liberally construed. And
So, excuse me, what are the facts here that would support your argument then?
well, first of all, as to the potentially exculpatory evidence itself, the alibi evidence, Mr. Moreland had an alibi in that he was at a recording studio recording rap music. He's a rap artist at the time when the robbery occurred. Then,
He has witnesses to that effect?
Yes, and so did the Akron police, actually. Mr. Moreland's trial counsel did not find out until after he had filed a motion to continue the trial in this case, which was filed about 6 days prior to trial, and was filed on the grounds that Mr. Moreland's counsel had not been provided with adequate discovery. It was after Mr. Moreland's counsel filed that motion and received further discovery that he found out that Akron police officers had spoken to witnesses who put my client at the recording studio at the 6:30 p.m. on February 13th.
And specifically, how is it that his discovery was inadequate?
That's not fully developed in the record, but apparently, at least to the extent that he wasn't aware of all the witnesses that would have corroborated my client's word that he was in a recording studio at the time.
How did he not know that? What the time of the event and where he was at that time until 7 days prior to trial?
Well, it appears from the facts in the record that my client must have believed throughout the entirety of the investigation of this case that the night of February 13th meant nighttime, meaning overnight, because when he turned himself in to Akron police, he provided them with receipts from a hotel showing that he had stayed overnight in a hotel with his girlfriend in preparation for the Valentine's Day.
Well, that only shows he hadn't checked out. Does it establish what you just said, a receipt for the hotel?
I would concede that a hotel receipt wouldn't show the time necessarily that he may have checked in or the time that he checked out, but the time on the receipt was for around midnight on February 14th, and one would think that one would spend several hours at a hotel if one's staying overnight as his girlfriend's, or as his trial counsel proffered during the course of the trial. But
So you're saying he was basically confused as to what time they are alleging the robbery occurred?
yes, thank
And
you,
as
Your
soon
Honor.
as soon as he found out that it was earlier in the evening, then he realized that he had some alibi evidence that he didn't realize he had before.
That's correct.
And he presented that to the court, and the court felt that he could have basically been more aware of it himself and delayed in telling his attorney and so forth.
Yes, Your Honor, that was essentially the reasoning. But again, in the interest of justice, when the police already have witnesses that also place my client at the recording studio at the time of the robbery, then it becomes, I argue, an abuse of discretion for the trial court to have denied my client the opportunity to present that evidence. Because as the courts in Ohio have said, a court can abuse its discretion if it denies a defendant the ability to bring in untimely alibi evidence, where the evidence neither surprises or prejudices the state, as in this case, the state could not be surprised by it, and so therefore could not be prejudiced by a lack of timely disclosure, and also that the defendant acts in good faith. As we just discussed, my client was confused as to the time when the robbery occurred, which, in my view, tends to show that he wasn't the person who actually committed the robbery. But the rule can't really apply against a defendant when there is when there is good cause for a delay, or there's some demonstrable or excusable showing of mere negligence on the part of the defendant. And one of the reasons behind the time limit in Criminal Rule 12.1 is to give the state the opportunity to confirm or disprove the defendant's alibi. And so, because in this case the state already had talked to witnesses that placed my client in the recording studio, the state could not be prejudiced by that. They already knew. But also, I would like to touch on the information from the co-defendant Kraft's Facebook page. In this case, one of the detectives who was investigating pulled up the Facebook page of the co-defendant, Ms. Kraft, and he actually made what's called a screenshot showing portions of her Facebook page. And my client tried to bring this into evidence, but was denied. Basically, on the trial court sua sponte objected to the potential exhibit on the grounds of authenticity, that it may not have been properly authenticated under Evidence Rule 901, and of course, with authenticity being a prerequisite to admissibility, the trial court didn't think that was authentic. But the trial court also expressed that it had doubts as to whether the information, which Detective Garrow had pulled several days after the robbery, would even be an accurate depiction of the Facebook friends list, which my client doesn't appear on. But that's not the test for authenticity. Detective Garrow clearly could authenticate it because under the rule, the person who actually makes a writing can testify as to its authenticity. So it was an abuse of discretion.
He took a screenshot of what he saw on the screen. He's authenticating that I took this picture, this is what it looked like at that time, but how's he going to authenticate what was actually on the Facebook site? And maybe somebody's been befriended in the meantime.
That is a valid point. I mean, he cannot authenticate the contents of it, but he can authenticate, this is what I had in front of me at the moment.
This is what it looked like at that time.
That's what it looked like at the time, but whether it had been changed or not doesn't actually go to it goes more to the weight of that evidence than it does the admissibility at that point. Just like a hospital record of somebody's treatment record. The hospital can authenticate that, yes, this is the record, but the person who's the custodian of records for the hospital, even if they come in and testify that, yes, this is a true and accurate copy of Mrs. Smith's or Mrs. Jones' surgical record, that hospital official cannot testify as to the accuracy of the actual information that's recorded by the doctors and the nurses in that medical record. It's the same thing with Detective Garrow. He can't testify that what is in the Facebook page, he can't testify to that because he doesn't have personal knowledge of that. He can testify that he has personal knowledge that he created the document.
Just that he snapped a picture.
He snapped a picture of it, correct. And at that point, it becomes its own document. But
The picture that he took.
correct. But like I said, it's just like a hospital record. The custodian of records can't say, yes, indeed, Dr. Jones operated in this way on Mrs. Smith's knee.
Well, except that, like Judge Shaker's saying, it's more of a picture, so you would usually have, it wouldn't be a custodian of the records for a picture, it would be the person that took the picture. Does this clearly and accurately depict the condition of the premises on this? Does this clearly and accurately depict, what you were viewing or whatever? So this is a little bit different, isn't it? Because you have, and I understand your argument, it goes to the weight, but it's taking a picture not of just what you observed in the house or what you observed outside, but a list of friends, which may or may not be accurate, because you're almost saying that it is accurate because here's the picture. This is what was on the website, this is what was on the Facebook. It's more of it's a picture more than a record. You're saying he created a document. I'm not sure he created a document, as he just took a picture of a document that already existed. With your scenario, it would be like somebody going into the hospital records and taking a picture with their cell phone of somebody's discharge summary, for instance, and then coming in and saying, here is a picture of the discharge summary. They're not a custodian of those records. They're just somebody that took a picture of a record. So that's why I'm throwing, I don't know. I mean, this is a novel issue for me. I'm trying to figure it all out in my mind. So what's your response to that?
It is indeed. I think, however, Detective Darrow could testify as to, I took this picture of this Facebook page just like I took this picture of the discharge record. What's in the discharge record is a slightly different question. You can testify that this is a true and accurate image of what was in front of me that I took, what was on the screen.
But it was taken 6 days after the event, I mean, after the incident. When was the snapshot taken? At the time, when we know who the friend list was at the time that the incident occurred?
We do not.
Because we could have befriended somebody in the meantime, and they're not going to show up there without even having a history of that, because all you did was take a picture on that day at that time. We don't have somebody from Facebook here saying that, but well, I have my records here showing that she befriended this person on February 13th at 6:49 p.m. We don't have anything like that. So we don't know what the situation was at the time of the event, right? What her friend list looked like at that time.
No, you're absolutely right. We don't.
So she could have been befriended, hypothetically. He could have been a friend and she bumped her.
Absolutely, and that would be a point that the state could bring out during further direct examination of Detective Garrow. It's like, well, we don't know.
How would he know that?
Pardon?
He doesn't work for Facebook. How would he know that?
No, correct, he doesn't work for Facebook, but the state could lay a foundation of have you ever worked with social media? Do you yourself participate with social media? Well, yeah, I may have a Facebook page of my own. Do you know whether you could delete friends at any time, at any point? Well, yes, and so could Ms. Kraft have, in the days between the robbery and today, have deleted, Mr. Moreland from the Facebook page? Yes, that's possible. But the point is that as of the day that Detective Garrow took the image, he can testify that that's what he saw.
And so your argument there would be that doesn't go to admissibility, that goes to weight.
Absolutely, Your Honor. And I see that
Yeah, I'm just
coming up on 20
going to give you
seconds.
another minute if you wanted to go, because we asked you a lot of questions. Do you want to discuss any of these other assignments?
Well, yes, although in a minute it's going to be tough.
Yes, I understand.
But I would like to
Can't
clarify,
even decide in the minute.
That's right.
where do I start?
That's right.
However, I do want to touch very briefly on the resentencing issue, just because that is, I can handle that very quickly. That is a very technical point. In this case, there was no restitution ordered by the trial court, and yet it says in the sentencing entry that restitution is to be paid first. The only reason that the assignment or this assignment of errors is raised is because the disparity raises some questions about the sentencing entry, and that's why resentencing is being requested. And with that, I would submit the rest of my assignments of error on the briefs. Thank the court very much.
Thank you.
And urge you to reverse. Thank you.
Thank you. Thank you for filling out our questions. All right, we will take the matter under advisement. We'll issue a written opinion, which will be sent to both sides, obviously, as well as released on the website. All right, thank you so much.